in welcoming Anne Latournerie from Documentation Française, which I am reliably informed is somewhat similar to HMSO over here. Anne joined Documentation in 2002 as the head of the publishing department. She's also worked as an editorial assistant at the independent newspaper and took part in the project to build a new French National Library. So, Anne, please take the floor.
First, I would like to thank you very much for your invitation. I have to precise that I am an historian, a practitioner, and not a lawyer, not an economist. I first met authors Wright working for the project to build a new national library in France at the beginning of the 80s. And of course, dealing with a digital project, we met the authors Wright. Then I have practiced authors Wright as a publisher, and I have decided also to study the French political and cultural history of authors Wright. I want to make first 3 preliminary remarks. First of all, moral rights, like intellectual property, is not an isolated question. It is linked with other key issues: the liberty to create, the way the work are circulating, the organization of a market, the place of the authors in the society, and other many issues. Secondly, both authors' right and copyright conception face double tension between authors and intermediaries, and tension also between authors and public interest. Thirdly, battle for authors' right in France were always battle of economics and moral rights. The double justification of IP, reward arguments, and also personality arguments have been mixed all along the history of authors' right. The French history of authors' right is full of political and cultural battle. However, clearly it is organized around the figure of the author, which centralizes all attention. So I will do first a quick drawing of the French history of authors' right, then I will go to the moral rights today in France, and we'll finish with the effect of moral rights. So first, the history. I will give you another look on 3 key moments of this history. First of all, of course, the revolution, which is really the time that we have the conquest of the author's right. It is the victory of the authors, which has the imprint of the Enlightenment philosophy. The abolition of the privilege leads to 2 major laws, the law of 1791 and 93. The posterity reminds 2 things: the role that the authors have played in the battle of the right, and also that it is a time that exclusive rights are consecrated in the hand of the authors, a reproduction right and a diffusion right. Of course, this has to be shadowed a little, because at the same time in France, like what happened in the States, there were 2 main ideas, not only the necessity to give personal right to the authors, but also the will to encourage the circulation of works and knowledge in the spirit of the Enlightenment. That's why the revolutionary lawyers say that public property is the rule, whereas author's right is an exception. However, at the end of the 18th, there is no doubt that the figure of the author has been reinforced by these 2 laws. And it also coincides with the emergence of the notion of originality as a new aesthetical category after the old literary theory of imitation. And the notion of originality is the foundation on which is built the philosophy of French author's right. So let's go to the 19th century. It is a key moment for moral rights. They are battled on 2 major subjects: the nature of author's right. Is it a personal right? Is it a natural right? And also, should it be limited or perpetual? There are many actors involved in the battle: economists, lawyers, but also many authors, very famous ones like Lamartine, Victor Hugo, or Balzac. Authors defend their rights in the name of a romantic philosophy of the author. And also, the 19th century is the time that we see the emergence of personality rights. So that all this leads to the fact that it is the moment when jurisprudence and doctrine build the first step of the main principle of moral rights in the 19th century. And it is also the time that France played a large role on the international level, introducing moral rights at the revision of Berne Convention in 1928, with Article 6 recognized paternity rights and integrity rights. But France translates the moral rights not before 1957 in a law, which is the first modern law which recognized both moral rights in the first place and economical rights. The first law which is adapted to the new form of cultural practices, modern publishing, radio, cinema. My surprise as an historian was to discover that this law was not the natural issue of a French juridical tradition, because many battles happened. There have been also, under the Front Populaire, a counter-project supported by the minister Jean Zay, and all the process before adopting the law in Parliament has been very long. It is a law of economical organization that stresses on property and tries to organize the profession. It integrates economy in the cultural field and realizes a compromise between the necessity of creation in culture and the necessity of production and exploiting works. That was very important, especially for cinemas, as I will show you later on. The paradox of this law is that the figure of the author, with the recognition of moral rights, is sacralized precisely at the moment when it has beginning to change completely. And also the law is mostly the law of the publishers, of the producers, who produce and make available the work. The new weight of the publishers and all the cultural industries has been started before the war, in the 20s and 30s, I must say. So what we learn from French history of authors' rights is that moral rights are definitely not limited to a few articles of law, but are an important and most representative sources of the philosophy of French authors' rights. Moral rights are symbol and power lever, I would say. So what are they today in France? First, I must precise that they have a central place in the code. I must insist on the key notion of originality, which determines if a work of mine, as we say in France, is protected or not by author's right. The idea is that there is an intimate link between the authors and the work, because work carries a personal imprint of the author. So the judge in France appreciate if there is or not evidence of originality, and this has nothing to do with anteriority. So the first moral right in France is the right of attribution, to be identified as an author of the work and to have its quality recognized. It's quite simple in practice in many cases, but new question appears also with the development of digital works. When and how to put the author's name became more complex with mixed works, collective works. Some fear that there will be an erosion of this right. Second right, the right of disclosure, the right to decide when and where to publish. For instance, it is derogative to this right the fact to put on internet the text of a song, for instance, as it has been judged for the text of the song of Jean Ferrat, a musician, French musician who just died, because he hasn't given his previous authorization for that. I can say also that in the famous affair of Whistler at the beginning of last century, it has been said that the painter was not obliged to deliver his painting, although the work has been ordered to him. What is an actual issue on this right is to know if the right of disclosure finished with the first use, or does it exist a disclosure by step, I would say, where the right goes on for each new diffusion allowed by the author. Laws are divided on this subject. The third right, it's the right of integrity, the right to object to derogatory treatment on the work. What I must underline is that in France, we look not only to damage to the work's form, mutilation, modification, but we also look to damage to the spirit of the work. Regarding damage on the work's form, of course, you can't make cuts in a text. There is a funny example of fractioning an artwork painted on a fridge, as the painter Bernard Buffet did, is not allowed. Then somebody wanted to sell the fridge pieces by pieces, but it has been condemned for that.